Order 8. Written statement set of counterclaim. Rule 1 to 10. The meaning of written statement is answer by the defendant of the plaintiff's suit. The defendant shall present his written statement within 30 days from the service of summons upon him. As provided under Order 8 Rule 1 As provided under Order 8 Rule 1 of CPC, the defendant shall present a written statement within 30 days from the date of service of summons on him. The period of limitation within which defendant shall submit a written statement is ordinary within 30 days from the service of summons, 90 days it allowed by the court. In the case of failure of filing a written statement within 30 days, the defendant can be allowed to file the same on such day specified by the court of the region recorded within, which shall not be later than 90 days. The period of limitation within which defendant shall submit the written statement is 30 days from the service of summons. Consider the following statement. A defendant may set up, by way of counterclaim against the claim of plaintiff, any right or claim in respect of cause of action occurred to him. The counterclaim shall not exceed the pecuniary jurisdiction of the court. A and B sue C for the recovery of 1,000 rupees. C has debt due to A alone. Here C cannot set off debt due to him by A alone. Set off can be legal set off, equitable set off. Under Order 8, Rule 6 of the set off is permitted by set off claim by the defendant a certain sum of money. In which on the following cases can set off can be claimed. A sue B on the bill of exchange rupees 5,000. C hold the judgment against for the recovery of debt of 1,000. If in any case in which defendant set up counterclaim, the suit of plaintiff is stay, discontinue or dismiss the counterclaim, nevertheless to be proceeded with. It is a suit if the suit is filed in the court have no jurisdiction, it shall be returned. In a suit, plaintiff himself wishes to appear as a witness without any permission of court. He may appear only before or any other witnesses on the behalf he has been examined. A prayer for the extension of the time period of 90 days for not filing the written statement neither A nor B can time extend beyond the period of 90 days, oral or written. On the default of the filing the written statement under Order 8, the pronouncement of judgment is discretionary. The provision relating to particular written statement and counterclaim is Order 8 of the CPC. Order 9. Appearance of the party and the consequences for non-appearance. Rule 1 to 14. Where a suit is dismissed under Rule 2 and Rule 3 of CPC, the plaintiff may bring a fresh suit in the subject of law of limitation. What the court can do with neither party appear when it is called for hearing. Dismissal of suit. Dismissal of suit under Rule 3 of Order 9 of CPC does not bar a fresh suit in respect of same cause of action. A suit can be dismissed by default under Order 9 Rule 3 and Order 9 Rule 8 of CPC. Which one of the following order of the court may pass order under 9 Rule 3 of the CPC? In a suit, neither plaintiff nor defendant appear on a fixed day of hearing. Dismissal of suit. A fresh suit in respect of the same cause of action is permissible where the suit is dismissed under Order 9 Rule 3. A suit may be dismissed where after the summon has been issued to defendant and returned unserved to the plaintiff failed to apply for a fresh summon for a period of 7 days. An application under Order 9 Rule 7 of CPC can made at any time or on before next day of hearing. Application under Order 9 Rule 7 of CPC sets aside the order of ex parte proceeding may be filed at or before date of fixing the hearing. Under Order 9 Rule 7 of the Code of Civil Procedure, the application can be made at any time or before the next date of hearing. A suit may be dismissed where after the summon has been issued to defendant and returned unserved, the plaintiff failed to apply a fresh summon for the period of 7 days. Where the defendant appear and the plaintiff does not appear when the suit is called for hearing, and where the part of the claim is admitted in the court shall dismiss a suit so far as it is relatable to be remanded. A suit dismissed under Order 9 Rule 8 of CPC for the non-appearance of the plaintiff is restored under Order 9 Rule 9. After the dismissal of suit under Order 9 Rule 8 of CPC, a fresh suit on the same cause of action under Order 9 Rule 9 of CPC is barred. In a court of civil procedure, an ex parte decree can be set aside under Order 9 Rule 13. An ex parte decree can be set aside on the ground of summon is not duly served, being prevented by the sufficient cause for appearance. An ex parte decree can be set aside by Order 9 Rule 13 of the CPC. In a suit for partition, three defendant were set aside ex parte. Preliminary decree was passed. On the application of one of three defendants, the court set aside the decree as against all the defendants. The order of the court is illegal. Where the appellate has withdrawn the appeal preferred against a decree passed ex parte, the application under Order 9 Rule 13 is maintainable. An ex parte decree can be set aside on the ground of summon were not duly served. When the ex parte decree is passed by the defendant, can file the application under Order 9 Rule 13 of CPC. Under which one of the following provision of CPC ex parte order or ex parte decree may be set aside? Order 9 Rule 7, Order 9 Rule 13. A suit may be dismissed under Order 9 of CPC where a summon is not served upon the defendant in the consequence of the plaintiff failure to pay cost for the service of summon, where neither the plaintiff nor the defendant appear, where the plaintiff after summon return unserved fail for 7 days to apply a fresh summon, where on the date fixed for hearing in the suit only the defendant appear, he does not admit the claim. In a suit for the recovery by institution against A against B, despite of summon of suit have been duly served upon, he did not appear on the fixed date. The summon on 1/3/1993. The court consequently on 1/3/93 passed ex parte decree against B and listed the case for 3/4/93. For the ex parte evidence, A can be participated in the proceeding of the case. B can seek setting aside ex parte decree in order if he is able to so. A suit may be dismissed where summon is not served on the defendant in the consequence of failure of plaintiff to take proper step like filing of the court fee, postal charge and requisite number of copy of the plaint. Neither party appear when the suit is called for hearing. The plaintiff after summon the defendant had returned unserved to fail apply. After being proceed against ex parte, the defendant is at the liberty to join the proceeding at the stage where the proceeding is the pending.